Good afternoon, everyone. We are ready to commence with our webinar for this afternoon. I am Diane Joseph, the Vice President of the TTCSI, and it is my pleasure to welcome all of you on board. But let me first recognize the President of the Trinidad and Tobago Coalition of Services Industries, Mr. Mark Edgell, and our keynote speaker, Director of the Greater Tunapuna Chamber of Industry and Commerce and Attorney at Law, and Sector Specialist, Ms. Indu Sharma, our CEO at the TTCSI, Ms. Vashti Gayadeen, Directors of the TTCSI, Directors or other officials of the Greater Tunapuna Chamber of Industry and Commerce, our members of staff at the TTCSI, and you, all our members, friends, and stakeholders. Let me say how nice it is for us to jointly host this webinar on estate planning in collaboration with the Greater Tunapuna Chamber of Industry and Commerce. It is indeed a very insightful presentation, a very dynamic one planned for you. And we trust that this is going to benefit you as you plan your estate. I would now like to introduce our president, Mr. Mark Edgell, and I will give you a brief profile on him as he brings remarks at this session. Elected in April 2021 as the 5th president of the TTCSI, Mark will serve for a period of 3 years. A former director of the TTCSI from 2016 to 18, he served on a tripartite consultative committee and was instrumental in assessing the needs of members through the development of a cluster approach. He is also the current president of the Association of Real Estate Agents, known as AREA, and leads a diverse portfolio of businesses in real estate, clothing retail, wholesale distribution, and energy management consulting. Ladies and gentlemen, my pleasure to introduce our president, Mr. Mark Edgell. Mr. Edgell.
Good afternoon. Thank you, Diane. Good afternoon, ladies and gentlemen, and all protocols observed, of course, to all our guests of all the different associations and our listening and viewing public. I want to reiterate what Diane just said in that we are extremely happy to be partnering with the Greater Tunapuna Chamber of Industry and Commerce to put forward this very important topic to our membership. The membership actually has come forward with a request for this information as well, which was firstly born through feedback that came from our participants of the Gateway to Trade program, and secondly also from discussions with members on our team would have had with most members and stakeholders during the course of the pandemic. Estate planning, and by extension succession planning, is important at any point, and more so since we navigated the pandemic and many people lost loved ones unexpectedly. Women who lost their spouses, partners during the pandemic, who lived in homes jointly owned by their spouse or partner, following their untimely deaths, the spouses or partners, relatives, would have come forward laying claim to their property. This is something that happens quite often when people are uncertain of what the wishes of their deceased relatives are, and they believe they will be taken care of, but when things are left unsorted or open-ended, it opens them up to risk of not being taken care of. And special mention needs to be made here on a side note that we have seen an increase in domestic violence necessitating relocations of persons in properties. For instance, since the start of the pandemic, we have seen an alarming increase in the acts of domestic violence where families or cohabitants had to be relocated, and the numbers during the period of March 2020 to 2021, there have been over 2,500 reports of domestic violence, which is a drastic contrast to the 1,000 odd reports that came in for the entire calendar year in 2019. So this is more than double the number of cases, and we also have to bear in mind that all cases are not reported. So it's far exceeding those numbers. Many people also believe that estate planning is something that's done only by the wealthy. This is extremely inaccurate. It's not true. And estate planning, and by extension, succession planning, is for anyone and everyone and should be given serious consideration. If you, for example, are a designer, clothing designer, your loved ones should know what your intentions or your expectations are in relation to those designs when you pass on. Who is going to own those designs? What are the plans for the use of those designs in the future? Have you copyrighted those designs? Have you registered your copyright or your brand name for those designs? If you're a musician, for example, what do you want to happen with all those songs you have written and that have not yet been recorded or published? Who gets royalties from the work that you already have published? These are questions that need to be answered, discussed, and planned for so that the wishes of the person that owns that intellectual property has their wishes properly adhered to, and the beneficiaries of their work can be passed on to them effectively. You also have the house, for example, that you would have worked very hard throughout your life to pay for. And you want to be able to pass on instructions as to what should happen to that house, who would inherit that house if you pass on. Are you dividing it equally among your children? If you have no children, are you dividing it among your nieces and nephews? Are you giving it to one relative? It's all about making a decision as to what you want based on what you have acquired through the course of your life and who you would like to move on with it after you have passed on. Securing your loved ones is not only about them waiting for your demise to inherit. It is more about having your hard work or hard earned property and acquisition throughout your lifetime to be passed on to those persons who you wish to leave them to. And for those people that you leave them to get them without interference and hindrance. So making your wishes known verbally is not a guarantee that you will have your wishes carried out. And this is why estate planning is the way of securing that and ensuring that your wishes are carried out. Estate planning is very important in our society at present, where a lot of wealth, tangible and intangible, may be tied up amongst families spanning generations. And too often, we hear about persons passing on, leaving their families in chaos as they did not have their business in order. We have situations where people are, for example, tenanting land and their relatives are unaware that the house is not situated on land that is owned by the family. The relatives who have inherited the property or the structure that's on the property decide to sell the property and are met with the unfortunate realization that the property is not theirs to sell. So they actually do not have the wealth that they think they had to disperse among themselves. So these are important things to understand, conversations that need to be had about where things are. Technology is also bringing another dynamic into play where people have online accounts, people have stocks and bonds that have been registered online through online software. You can even take a point from the guy who has Bitcoin, and he could not remember his password. So while he could have been one of the most wealthy men in the world right now, he is not, but he has no access to his Bitcoin because he has no access to his passwords. So if people pass on and do not have anyone who is aware of all of their assets and where they have all their holdings, and through what mechanisms they have their holdings, no one is going to know where to look and no one is going to understand what to do about them to gain access to them. So this is why this afternoon is very important. And it's our intention through this session to elaborate on the issues and during the question and answer segment to begin answering some of your questions. We are very fortunate to have Ms. Indu Sharma. with all her wealth of experience joining us this afternoon. And it's my pleasure to hand you over to Indu to take us through all the specifics of the succession planning and touching also on a little bit of succession planning and its importance where business is concerned. Indu?
Thank you very much, Mark. It is a pleasure indeed to be here and to collaborate with Trinidad and Tobago Coalition of Service Industries. I want to express my thanks from the get-go to the TTCSI and to GTCIC, Greater Tunapuna Chamber of Industry and Commerce, for allowing me this opportunity to share some thoughts and some concepts, perhaps even some strategies in relation to succession and estate planning. And I think what we want to get to is to start everyone thinking about developing a plan for your family and for your businesses. We have adequate time for questions, and please, I think Diane will be receiving the questions in the chat, and if you have questions, please do put them in the chat and we'll take them at the end. I think it will be very informative, and I think also what we want to get to is, sort of practical considerations that you may think about and act on. So let's just start and say that, estate planning is a subject that traditionally no one really wants to talk about because it has a lot to do with our mortality and, our demise, and perhaps not a pleasant thought for each of us to think about. But I would say, as Mark mentioned, that COVID-19 has presented many challenges over the last almost 2 years. And many of us have recognized the fragility of life and the reality of our own families and relatives, friends, having to deal with death at an unexpected time or the unexpected death of a loved person. So these circumstances may have consequences that may create more difficulty. So to start us off, I would like to just ask a few questions to get us going and to get us thinking. And one of the questions that I would like to throw out to everyone is, how many of us actually take responsibility for our financial affairs? How many of us relinquish that responsibility to a spouse or a partner? Are we aware of our marital bank accounts? Are they joint, for example? Do we live in a home that we own, as Mark mentioned? Or is that home the home we live in, is it held jointly? And if it is held jointly, who are the joint owners of the property? Is the property mortgaged? And if so, do we know what the balance on that mortgage is? What's the debt on that mortgage? If something happened to our spouse, how would that mortgage be paid? Or if something happened to us, how would that mortgage be paid? Is the car that you drive in your name? Can you easily make a list of your current assets? And even can you easily make a list of your current debts? And I think it's really important for us to be in that space and thinking about facing our fears of the future, but as a mitigation for that, planning for the future is really, the way to go. And I also would like us to consider the perspective of those who survive us, our family members who survive us. How would they, if anything happened, how would they access cash? How would they live? How would they continue to live in the home? Who would pay the expenses that are day to day, regular utility bills and so on? So these are really very practical considerations where, we have to think and think about the future, because it really is the day-to-day existence of our loved ones that we will need to think about after our demise as well. And I'm sure many of us have the perspective that we take care of our loved ones and we provide for our families. But I would like to suggest that planning for our demise is just an extension of that perspective and taking care of the future of our loved ones. We can't predict the future, but a good plan helps us alleviate and mitigate the difficulties that our families may face in the future. And hopefully sharing this perspective will make us aware of some of the processes, some of the legalities, a few of the complications I'd like to mention. And all of this will help us feel motivated and incentivized to start thinking about planning, not only for our future, but for the future of our loved ones as well. Next slide, please. So here are some terms that we may or may not be familiar with, some basic legal concepts. And I'd like to just go through the list and explain a few of them and clarify a few of them. So a will really is a written expression of your intention, your wishes rather, as to how you would like your assets to be shared in the event of your demise. It can be changed from time to time, and it applies to your wishes on the distribution of your estate. Your estate happens to be the assets that you have in your sole name as at the date of your death, okay? This doesn't prevent you, a will and thinking about your estate doesn't really prevent you from acquiring or divesting yourself of your assets or selling your assets if you choose to, or giving them, gifting them to other relatives. But the critical thing to remember is that your estate comprises whatever you die possessed of in terms of assets as at the date of your death, and your will apply as at the date of your death. Intestate simply means a situation where you pass away and you have not made a will. So you are testate when you've made a will, and intestate, meaning without a will, if you don't have a valid will. And in this case, the law prescribes how your assets will be distributed. 50% to your spouse, if you have a spouse, and the other 50% divided equally among your children. So there's a significant difference there. If you have a will, you can choose how your assets are distributed. If you don't have a will, the law will take care of how your assets are distributed. Another choice that you can make by making a will is the appointment of the executor. And the executor is the person who you choose to administer your estates. And the administration, or the responsibility of administration, is really collecting in the assets. First of all, applying for the probate of the will, collecting in the assets, and distributing same. In the case of an intestacy or an intestate person, and where there has not been a choice of executor, the next of kin is entitled to apply as the person who administers the estate, and that person is called the administrator. So there again, another important distinction in terms of having a will and appointing your executor, or not having a will, and therefore your next of kin is the one who is entitled to apply for your estate. Now, the grant of probate is the document that the executor will use and have the authority to administer the estate according to the instructions in the will. If you don't have a will, that same document is called the letters of administration. And it is the same thing. It gives the next of kin the authority to administer the estate in accordance with the law. Beneficiaries can be named in a will. So we refer to beneficiaries as the beneficiaries of the estate, or the by law, the beneficiaries, if you don't have a will, are the ones who are entitled to receive the proceeds of the estate. I would like to just mention this point about joint property as well at this point. The importance of understanding the implications of having joint property relates to estate planning as well. Joint property does not form part of your estate, and therefore these assets that are joint with other persons are not considered a part of your estate. So that's an important distinction to make and an important point to bear in mind. Can I have the next slide, please? Okay, so we're going to talk a little bit about processes and what is involved in preparing a will, execution, application for a grant of probate by the executor or letters of administration, and the payment of debt, the question of time, and what the distribution entails. In order to be valid, there are certain formalities for execution of a will. And when I say execution, what I mean is the signature of the will by the person who is making the will. We call that the testator. And these are legal formalities that need to be complied with. The will should be in clear and unambiguous language, and you must be able to, as a person making a will, you must be able to be capable of understanding what you're doing. And you must not be subject to undue influence. So formalities for execution, the wording of the will must be clear. You must have the right capability and capacity to know what you're doing and not subject to undue influence. Once the testator passes away, the executor who is named in the will must apply for a grant of probate, and there are certain documents that need to be prepared for that application, including the original will. And what we also prepare is an inventory of the assets. So simply put, a list of the assets of the estate. So you need to know what the estate comprises and what the value of the assets in the estate. So if it is a bank account, for example, what is the amount of money in the bank at that time, the date of death? Many times, documents and information may not be at hand, and this indeed can cause delay. So again, a really good and compelling point to make sure that you are aware at any given point in time what your list of assets comprises. Application for letters of administration, I mentioned earlier, is made by the next of kin. And for example, if you are married, that would be your spouse. If you are a widow or a widower, that would be your children, would be considered to be your next of kin, and so on. There's a regime for who is to be considered the next of kin. One of the responsibilities of the executor or the administrator, in the case where there's not a will, is the payment of debts of the deceased, and then the distribution of the estate thereafter in accordance with the instructions of the will, or if there's no will, there is a regime for the distribution of the assets to the next of kin. All of this can be a time-consuming process, especially if there is little information as to what the estate comprises, or there are doubts as to what the estate comprises. It can take time identifying those assets. And then the application itself is a process where the application is submitted to the registrar of the court, and that also can take time if there are any queries or if there are any issues with the application. So it can be a while. At the moment, it is a bit time consuming. And we have seen that prior to COVID, we were able to get grants in perhaps maybe 3 or 4 months. But at this time, we're still waiting on grants, unfortunately, because of the intervention or the interruption of the COVID period. Next slide, please. So the 5 C's that I have put together that kind of, memory aid for us. The first one is choice. We always have choices with respect to our assets, and those choices can be reflected in a will. But we can also choose what property would be made joint during your lifetime. How would you like the assets that you have to be shared, and to whom? And the third one, which is perhaps one of the most important points, is who would be responsible for administering the estate. So I think one of the main points to make is the fact that when you have a written will that's valid, there is a clear choice that you can make over an automatic distribution of your estate in accordance with the law. So nothing is left to chance. The other thing about a will, and one of the points that Mark made, is the fact that it is a written reflection of your wishes, and therefore it is clear and speaks specifically to what you, as the maker of the will, the testator, would like to see. One point about writing the will, as a will can be changed from time to time, and it is the latest will in time which will be the one that is used to administer your estate. I would say communication is one of those things that's really very important. Communicating to your family as to what your intention is, what your wishes are, and making that clear, because so there are no surprises and that those wishes are respected. Particularly communication with respect to the executor is important. Your executor is a choice, and one of the things that we suggest to our clients and our stakeholders is that if you're going to choose an executor, you should communicate to that executor and perhaps ask them whether they would like to accept this responsibility. It is quite a big responsibility, and that person must have the wherewithal to look at instructing a lawyer to actually complete this process. And once the grant of probate is received, they have the responsibility of collecting in the assets and dealing with them in accordance with the will. All of these 3 C's, the first 3, in my mind, lead to certainty for those who are left behind, and to a large extent, comfort to those who are left behind, because they are, this level of certainty will create the least amount of disruption and hardship on a family that may already be going through some level of emotional hardship as well. One thing I would like to suggest as well, and I know that we have some lawyers already in the audience today. So this is not just a plug for me personally. It is to seek legal advice from a trusted advisor that can give you the proper advice. Okay, this is really important because there are some little pitfalls, for example, improper execution that can lead to unintended consequences and further delay. Next slide, please. So I want to talk a little bit about practical advice, and this is really in the context of our Trinidad and Tobago entrepreneurial culture. And the TTCSI and GTCIC are all about entrepreneurship and promoting entrepreneurship among our communities. And in our entrepreneurial culture, sometimes we see businesses being strengthened or being built, in fact, on the personal asset base of the entrepreneurs. Or they may be used at a certain point in time to secure financing or what have you when the businesses are growing. Very often what we may see is that there's no real separation between the assets of the business and the personal assets as well. And this, there's lots of cautionary tales around this. Mark referred to them around, generational wealth and so on. Where there's not adequate separation of business assets and personal assets, that can by itself have disastrous consequences for families when there is the demise of the key business owner or the key business individual, the person who really operates the business. So here are a few practical suggestions to think about if you are an entrepreneur. One of the things that we should do from time to time is make a list of our personal assets and update them from time to time, because we may acquire more property or more assets, or acquire shares, what have you. Or we may also choose to liquidate those things. We may choose to sell, we may choose to make gifts, and so on. As far as possible, if it is possible indeed, it is advisable to keep business assets separate from personal assets. That way, the family, the circumstances of the family don't necessarily change depending on the fortunes of the business or the demise of the primary business owner or the key director. So that would be one practical bit of advice. Some people keep that distinction by setting up a separate legal entity to operate the business and keep the assets of the business separate from the family or personal assets. I really like the examples that Mark shared around designers and creative people, musicians, singers, people who are involved in media, people who create content. These are great examples of where, a situation where there is a lot of blurring between the business, the assets of the business, and the assets of the individual, or there can be. So it might be a good idea, especially in these situations, to segregate and separate the business assets from your personal assets and deal with them separately. Adapt your plan based on changing circumstances, both in your business as well as your personal asset circumstances. And I think one of the things that you should think about as business owners is this issue of succession in the business. Just as you plan for your estate, succession in the business, who will take over the business in the event something happens to you, is an important factor. And making sure that you have perhaps a little bit of a pipeline or training within your business to have someone come into the business, whether it is a family member or not, to operate the business in the event that something happens to you. I think there's also a distinction and something to consider between planning for the future and retaining control of whether it be personal assets or business assets. And that is something that there's a balance to be created, because we do want to plan for the future, and we do want to secure the interests of our relatives, our family, our loved ones. But at the same time, for example, we may not want to put our home in the name of our young children, even if they are adults. So we may, use different strategies to deal with that kind of thing. So it is a matter of, planning, looking at strategies, looking at actions that will be effective and making things smooth for the future, but also retaining a level of control. And to an extent, the will allows you, making a will allows you to retain a certain level of control. And the other additional factor is that you can change your will from time to time. Business advisors, accountants, lawyers, and bankers can be quite helpful when it comes to making that distinction between personal assets and business assets. And again, I would recommend that you seek the advice of your lawyers in this exercise as well. I know we have some questions coming through on the chat, and perhaps this is a good point to take a little break and receive some of those questions. And let's make this as interactive as we possibly can.
Okay, thank you very much, Inu. We will take a few of the questions and then we will get back where we were. So I'm seeing here, if the person with letters of administration dies before the distribution of the assets of someone who was intestate, what are the next steps?
Mm-hmm. There is another application that can be made. It does make it a little bit more drawn out, but there's another application that can be made to make sure that the assets of both estates are administered. Yes.
So is the time, I guess it might help the person asking the question as well. Do you have an estimated time frame for something like this? Is it 6 months? Is it a year? Or is it unpredictable?
It can be, because as I mentioned earlier, prior to COVID, the simple estates, let's say, where the applications were very straightforward, 3 to 4 months from start to finish. But now with the COVID, it has become more difficult. And then there are matters of the complexity of the application that sometimes cause delays. For example, if there are several names that the deceased is known by, the application needs to be made in all of those names. We need to swear supplemental affidavits to show that this person called AB is also the same person known as XY. Yes. So there are little complications like that can cause delay if they're not addressed in the first instance. So it can take a little bit of a while. At the moment, we are receiving grants that we filed about a year ago.
Okay, thank you for that. Next question. Since joint property does not form part of your will, does this mean it automatically becomes the sole property of the surviving party?
Generally speaking, yes. And when we talk about property, we're talking about house and land, real estate, okay? Generally, yes. If the property is held as joint tenants, it goes automatically to the other party. But there is a situation where property can be held in a different capacity, which is called tenants in common, where the shares are distinct, and that the share of the deceased goes into the estate. So it's a little bit complicated from that point of view, but a reading of the deed would be able to determine what's the appropriate, how the property is held and what's the appropriate consequence.
Thank you. The next question is an interesting one. How does one next of kin as a child seek redress if the parents pass on intestate and another child seek to sell property with no letter of administration?
Wow, that's that I know that kind of thing can happen, right? Yeah. So if I think this is one of those situations where you need to, a child perhaps may not be able to seek legal advice, but I would just say that property cannot pass, the title to the property cannot pass effectively and correctly if there has not been letters of administration. So anyone who is purchasing that property and their lawyer will be searching the title to make sure that everything is in order in relation to that property. One of the things you mentioned, if a child is a beneficiary of the estate, that interest cannot be transferred unless there is a trustee or a guardian who has the authority to transfer that share. So it can be complicated. And I don't want to get into specific situations because you don't always know the facts. But in general, anyone who is purchasing a property will have a lawyer that will search the title and make sure that the title is in order before that property is sold.
Nice, thank you. And we have how long after a person's death can a letter of administration be applied for?
There's no time limit. There's no time limit. Sometimes that, it takes a number of years for these applications to be made for various reasons. Sometimes you may have the next of kin, not being physically able to perhaps attend to the business. Sometimes it's they may be out of the country and they may have to appoint someone else to look after this this undertaking for them. So there are sometimes situations where the grant is not applied for immediately. Okay. I have a situation like that right now, and sometimes what happens is that the next of kin is not aware of a property that might be in the name of the deceased person. And when that comes to light, then the application can be made. Yes. But there's generally no time limit.
Having said that, if that is the case and someone applies for a letter of administration and then they discover another asset, what happens?
The application needs to be amended to include that other asset.
Excellent. If you are included in someone's will, can you include that property or asset when making your own will?
Whatever you are entitled to as at the date of your death forms part of your estate. So yes, you can make that part of your estate and deal with it specifically in your will if you wish. Yes.
Diane, if I could ask a quick question.
Sure.
All right. Indu, can you break down for us how an estate is divided? If someone dies intestate, for example, if a man dies intestate and he has a wife and he has children,
Yes.
I've been told it's 50% to the wife, 50% shared among all the children. Is that
Yes,
correct?
that's
Okay.
correct.
Are there any other deviations from that? If the person was not married to the if it's common law, or do those things get potentially complicated by marital status, by domestic status, if whether they're separated or not, or what can be a factor that will cause problems in that particular process to make it not as straightforward?
Correct. Good point, Mark. Common law unions are recognized by legislation now. So if you are a common law spouse, you are the next of kin as far as the law is concerned, and you can apply. What makes it complicated is if, for example, you are still legally married and you're not divorced, and you might be separated. So in those circumstances, you may not want your spouse to be the next of kin, all right, the automatic next of kin, and you may choose to make a will. If you are separated and perhaps have another relationship and are living with someone else, and that person is considered to be your common law spouse, these are the things that can create complications and circumstances where you may want to have more clarity in relation to your assets.
And okay, thanks, Mark. You okay with us? Nice.
Yeah,
So
I was trying to unmute to say thanks, Indu. Thank you.
Nice. So let me go to another one on the chat here. What is your advice regarding a situation where an elderly person who has land in their name but is now no longer of a sound mind and unable to execute a will?
What's my advice?
How can something be put in place for transferring the land to a relative?
Well, that's not necessarily, if you, the fundamental point is that whoever is dealing with their own assets really needs to be aware of what they are doing, whether it is to transfer inter vivos, meaning, during their lifetime, or whether they are making a will where the properties will be transferred afterwards. Because those types of transactions, if the person is not understanding, and the person does not have a clear understanding of what they're doing, those kinds of transactions can be challenged. And, the short answer, I don't know if this is the satisfactory answer, but the short answer is deal with your assets when you are, in your full mind, full senses, full understanding, rather than, do that sooner rather than later.
Indu, if I could just throw
And if the
something.
person dies before all of this takes place, it means that it is further complicated and it has to go through the administration process, is it?
Yes, and it will be the next of kin who is entitled, whoever the next of kin is, to apply for the estate.
Right,
Sorry,
Indu,
Mark, you can go ahead.
if I can, Indu, there's one, I'll just throwing out a scenario to you. If there is an individual, as the question just now was, an elderly person who is no longer of sound mind, and what can be done to transfer property? Now, I'm not sure if transferring property is the issue, but the power of attorney, which is necessary to be able to, in other words, carry on, whether it is ensuring the person is properly cared for, accessing their finances to pay for care. If, for example, someone needs to liquidate a property for them to be placed in a care facility, so to speak, and those funds utilized to pay for that that care prior to their death, I'm told that it's very difficult to get power of attorney, regardless of the fact. It's difficult to get power of attorney to protect the elderly from being taken advantage of. So in a situation like that, what is your recommendation, or is there an instrument that you can put in place in advance of someone reaching the stage where they're incapacitated or no longer of sound mind that will allow someone to have that that ability to make that request?
Yeah. Just as we say, you should be of sound mind when you're making your will, and your sound mind when you're making a gift or a transfer of property. Equally, if you are intent on granting someone a power of attorney to act on your behalf, that's one of the things that you should do when you are in your full senses and understanding of what you're doing. There is a process, a legal process, which is not much used, kind of, I would say, has been used in the past for people who are mentally ill, a conservator type of appointment that is made by the court. It's not necessarily a preferred application because, when you make an application to the court, it becomes public. And therefore, it's one of those things that's quite delicate. And it's not something that, families choose very often to do unless it's absolutely necessary. But what I would say is that, while we are relatively healthy and people are living longer and longer these days, it becomes more and more imperative to look after the financial affairs, your own financial affairs, to make sure that you're not a burden on anyone else, and that your family, your relatives, your loved ones are not out of pocket having to take care of you. So, it's just perhaps for our generation to think about those things as we go forward. It's unfortunate, and I do know of other situations that you mentioned where, it's very, very difficult and on the families concerned.
Thank you.
And we have another interesting question here. Must all wills be done by a lawyer for it to be legal?
No, the answer is no. But I would say that you may want to consider having the benefit of legal advice, because there, as I mentioned earlier in the main talk, there are certain formalities that need to be complied with respect to the signature of the will. And for example, and Mark and I talked about this before, if you're a beneficiary of the will, you can't sign as a witness. And these are little things that, you know, can invalidate the whole will altogether. So whereas anyone can make a will and have it witnessed in accordance with the law, it's advisable that you seek legal advice. There are also sometimes complications. If you write your will yourself, you might make it a little bit more confusing and make the estate itself difficult to administer. So I would advise caution, and I would always err on the side of seeking professional advice.
And in addition to that question, is the will required to be registered any place, or if someone does a will and it is lodged with their attorney, is that legitimate and a sound decision or transaction?
Those are two great questions. First of all, the will is a private document. And it does not need to be registered as such. It's a private document, and it can be changed from time to time. You can revoke a previous will and make a new will. Wills can be lodged in the registry if that is the intent and the wish of the testator. That's one option. But you raise a good point as to where the original will should be kept. As I mentioned earlier, when you are applying for the grant of probate, the original will needs to be produced and submitted with that application. So it's very important that you keep that will in a very safe place. Sometimes clients will ask their attorneys to hold the will for them in safekeeping in a safe, a vault, or what have you. Personally, I don't necessarily want to take that responsibility, but sometimes it is a request. That is a serious responsibility. So generally, the original is given to the testator, or testatrix if it's a female, and they are advised to keep it in a safe place, and also to make someone else, perhaps the executor, aware of its location and the contents.
In the event that they cannot find that original, what happens? But the attorney has a copy.
An application can be made for to prove a copy of the will. It is much more of a difficult application because you have to explain, you know, the circumstances of what may have happened to the original. Sometimes there could have been a flood, and the will have been destroyed, or a fire or something like that. If that is the case, it is possible to prove a will. Sometimes the will may have been destroyed by the testator himself or the testatrix himself. So it's a higher standard of proof. It's not an easy application. And so if for some reason you're aware that you have made a will and it has become destroyed, or it has been compromised because it's damaged, or so, the advice would be to just make another one, do another one, an updated one. And that would, the later one in time would be the one that can be proved, later original.
Here we have a question. Does the executor or administrator get paid?
Not automatically. If you wish to pay your executor, it's something that you can provide for in your will, but not generally. No.
And well, we have a whole lot, so let me know when you're ready to go back. If you have to finish any more in the presentation, because we have questions coming in.
Well, a lot of the
When
questions
it was
have
said,
covered, sorry. A lot of the questions are actually covering some of the material that I was going to cover, so it's fine. So let's just go with the questions.
All right. When it was said that joint property is not considered as part of your estate, does that apply to tenants in common, where one of the party dies? Can their family make claims?
I think we addressed that, but just for clarity, tenants in common is the situation where real property is in separate shares, and the shares are can be dealt with as part of the estate of deceased. So if, for example, my spouse and I hold property as tenants in common, my share on my demise would be treated as part of my estate. The other half share is treated as my spouse's property.
Nice. I have another interesting question here. How does a will supersede marriage agreements by law for less than 5 years?
That's a complicated question. We don't recognize premarital, as far as I know, premarital arrangements. You're talking about prenups, right? Prenuptial arrangements. So, you know, the thing about it is prenuptial arrangements are exactly that. They're contracts. And like any other contract, they can be enforced. They're usually private as well. But the will, if you make a will, that really is the expression of your intention as to what happens to your estate. A premarital arrangement may relate to assets that you have separated out of your estate. So I would just leave that there.
And I know we spoke to the issue of the registration of the will, but in the event that someone is not aware, how can a person find out if a deceased relative would have prepared a will? Is there a registry that we can go to? And if it is not there, what do we do?
What we do when we make the application, before we make an application for a grant of probate or letter of administration, part of the process is to search to see if any wills were deposited in the registry, because that's an option for a testator to do. If there are no wills deposited in the registry, it is likely that there hasn't been a will, or a will doesn't, you know, there's no will existing. This is why communication is so important. And, you know, the responsibility is on us as persons who would like to deal with their assets in the right way, to make our intention known, to share information about what we have, what we intend, and to perhaps, depending on our circumstances, give the original will to the person we've chosen as the executor.
Okay, another question. Does a grandparent have rights to a house that they have lived in with their grandchildren over those grandchildren?
Okay, so when you're talking about rights, you're saying that the property is not owned by the grandparents? I'm assuming
it gives the impression that the grandparent is living in the same house with the grandchildren.
But who owns the property?
who is the owner?
The children's parents own the property, or the grandmother own the property?
That is not any question. So maybe the question does not include that, but I think for the benefit of the person asking, maybe we can answer both scenarios. If the grandparent has any parts, or if it does.
Okay, let's take the easier scenario first, which is if the grandparent is a partial owner or the owner of a property, then the property cannot be dealt with without, you know, the consent and the signature and so on of that grandparent. They can't be put out, they're partial owner. If they're not an owner, you know,
1 second, Hindu also, that grandparent has the choice of who they choose to leave that property to.
Correct.
You can leave it to one or all, or none.
Correct.
Right.
Correct. So, and then the situation, if the grandparent is not the owner, and they are in a property where their children or their grandchildren own the property, it is a matter of equity, I would say. And it's a matter of, there would have to be a determination made. So sometimes you might find relatives putting people out of their homes if they're not legal owners. And, you know, that in that instance specifically, you really need to have some legal advice there in terms of how you counteract that, that situation.
And we have, is there an age limit after which a medical certificate is received to prove a sound mind, or is it subjective?
It is somewhat of a matter of judgment for the person who is preparing the will. So in the case of clients that we are familiar with, I can just give an example, that we are familiar with, that we've known for years, we've done business for years. We may have a certain level of comfort and understanding and a certain relationship with the individual client, and we may, we have an idea that they know what they want to do. If it is someone who we don't necessarily know, and perhaps they are brought into the office by a relative, these are things that we have to assess. And a medical certificate in any circumstances at any age could be one of the things that is required.
Indu, if I could just ask a quick question. I just want to jump back to the issue with the grandparent and the grandchildren living in a property. If the property was owned by the children's parents, so the grandparents' child, and the child has passed on, and the will was, or there was no will, it was intestate, so it should, in other words, go to the children. Can the grandparent have, not necessarily claim on ownership, but have protection from being put out by way of tenancy, by occupying the property as a tenant? Or will they be considered a tenant and therefore have rights and protection under that?
So Mark, the sort of, I appreciate what you're trying to say, and we do appreciate where older people are especially involved, and they do need some level of advice and protection. I don't know the individual circumstances, and I don't really want to opine on that. But what I would say is that, artificial arrangements don't necessarily protect people, or or not necessarily in their best interest, So if it is a genuine tendency, by all means, for sure, no problem. Perhaps that is just a reflection of the accurate circumstances, the facts. But artificial arrangements,
I think this clearly defines the fact that you need to have your business in order, because you can potentially have so many loved ones unfairly treated, and put out a property, and left at a significant disadvantage when it's not what your wish is.
Correct.
So I think all of these questions in terms of where what would happen and what could happen could be mitigated by putting your affairs in order and having your estate properly planned. So I think that's why we're here today, to learn and understand how important it is.
Yeah. And one thing to remember, Mark, is that we can't predict the future, and we can't predict how people are going to act or react in any situation. Okay, that is out of our control. But what we can do is try to express our intentions clearly and have that level of planning that will afford us some level of comfort and do the best that we can for our relatives.
So it goes back to our personal level of responsibility and commitment, ensuring that we protect those that we love and want to share our assets.
Yeah.
So the question here,
particularly those that are your dependents.
Yes. So my question here is also interesting. Is there an alternative approach besides having a will and then needing to probate? Example, could we consider trust fund foundation with trustees and beneficiaries as a means of wealth succession?
Yes, all of those things are possibilities, not commonly used. Some of the banks in the past used to have branches that looked after estates and trusts. But it's quite an onerous responsibility to give to an individual to carry on a trust. So I think that's something that you need to consider, and also the value of the assets in the estate, that you're looking to conserve. Trying to, and again, it comes back to that balance of controlling how your assets are distributed, but also safeguarding at the same time. And sometimes when people are very concerned about control, they create more complications. So my personal view is that, simple is better, and there are means to deal with your assets some you may choose to deal with some of them outside of your will, which you can do during your lifetime, and then the rest of your estate in the will and be administered by your executor.
Thank you. Our next question, based on an initial will, life cycle stage and change of assets with average health, what is an average recommended cycle or time frame for our updates?
For our
updates. So updates.
Oh. You mean, how often are you going to call your lawyer for an update?
Well, based on the average life stage or change of assets that we may have, is
for an update on your will. Okay,
yeah,
understood. Yeah. That's a personal choice. Things can happen quickly, or things can, generally, think about your own life, think about your own life cycle. Your asset base when you are in your 20s may not be the same as in your 40s, for example. In your 20s, you may not have children. In your 40s, you may have children. So personal circumstances change all the time. And it's not necessarily a fixed cycle or fixed interval, as it were. It really is for you to assess, how your life is developing, how your business is developing, how your assets are being acquired.
Yeah, so when you or when you acquire additional assets, depending on the size, you would make that personal choice. That's what you say.
The choice.
But Indu, it's not necessary if you are acquiring additional wealth or assets to amend your will if your will is simply stated, because it just
Correct.
means everything that you are acquiring is going to be divided as per your instructions.
Yes.
So yeah,
yes.
unless you want to leave things to specific individuals, that's a different situation.
Correct. The will can be very specific, or it can be very general. And again, your legal advisor will be able to help you with that.
If a child, not by blood, meaning not your own child, claims the deceased as his father, being brought up by him, does he have claims on the letters of administration?
Mm-hmm.
So like adopted?
It will be more as an adopted, because what they're saying here is the child was brought up by an individual and he considers this individual to be his dad.
Mm-hmm, mm-hmm. Yeah. So there's a distinction between, legally adopted and, just perhaps something like a familial relationship.
Yes.
Yes. So in those circumstances, those are circumstances where you would want to make a will and make it clear that, this person is your, or you consider this person to be your son, and therefore, you are making provision for them in your will. If you're not legally adopted, you would not be considered next of kin.
If I could just ask a quick question on that.
That's very important. Yeah.
Yeah. If I can ask, if a child is okay, if someone remarries, do they automatically have obligation to their stepchildren? And do the stepchildren have claim? Because technically you're not legally adopting them, but they become in your care.
Yeah.
So if they're not blood related, that comes back to a similar situation.
Yes,
How,
yes.
how does that impact on that, on rights and claim?
Correct. So when you make the application for letters of administration, you know, it is your blood relations. So for example, Mark, if you had, you know, if you were married twice, let's say, and you had children, all of your children, all of your blood children would be entitled to share in your estate, okay? But not stepchildren necessarily, unless they were legally adopted.
Okay. So and unless you want to state clearly in your will, so you need to have your estate planning to provision for them. Okay, perfect. Thank you.
And this is also a very interesting question here. What is your view on the fact that all documents should be digitized? What happens with the liabilities? I have heard that notices are put in the papers for any claims. This is not clear. Do you have any information that can clarify liabilities for persons that have deceased for the executor to be able to handle these matters?
It's a very good point, especially now that, you know, we are in a digital age. And the current process is for the application to be advertised in the Gazette and the newspapers, so that anyone who has a claim against the estate in terms of a debt or any liabilities, they will know who the executor is, and you know, if they can prove their debt, they will be paid out of the estate. But one of the things that the executor does is to ensure that the liabilities of the estate are paid. So the fact that the intention, let's say, of the advertising the application is also to protect the executor, because it's advertised publicly, so that, you know, and they have a certain amount of time. Anybody with a debt or a liability has a certain amount of time to make that request of the executor. But it's a very good point, because I don't know how many people read the papers regularly these days, and the Gazette is something that we get in the lawyers' offices and in the Parliament, but we don't really get anywhere else. So.
Here we have digitization as something that is going on around the world and more popular with every passing day. What is your view on digitization of documents, and how can digital documents be verified so that they are valid as the original in case of any damage or loss, and I guess of the original document?
Mm-hmm. Well, you know, perhaps this is something that we have to raise, you know, at a different level. I can speak to the current process. Let's put it that way. I can speak to what is required of the current process, and the current process requires the original document to be produced, and the grant is issued on that basis. It's something that perhaps our Ministry of Legal Affairs might be interested in addressing, along with the entire digitization of the probate registry and other legal
digital
branches
signature.
of government.
Yeah. I know we need to have legislation.
Yeah, but I don't think that given the nature of a will, a digital signature would suffice under current
regime. Not under the current legislation, correct.
And we have lots of interesting questions here, because these are things that continue to affect us. If you and your beneficiary die at the same time, what will happen to your assets? Can your beneficiary, so the beneficiary of the deceased beneficiary, claim your assets?
Yeah, the short answer to that is it depends. Like many questions in law, it depends on how the will is written. And so there are provisions that can apply that a named beneficiary must survive you, first of all, in order to inherit his or her share under the estate. If your beneficiary dies after you, then it generally is treated as part of their estate to be dealt with under their will or the application for the grant of letters of administration if they are intestate.
And in the, just a question here, I'm actually told similar scenario, if two persons die at the same time, literally in the same accident or something, that their time of death is what's going to determine whose last will and testament is governing the estate, basically.
Yes,
if it's a husband and wife die, if the husband dies first, it means the wife's estate or the wife's will is what's going to be administered, correct?
Yeah.
Right.
Yes, and but there are also provisions that you can include to clarify that. Okay. So again, legal advice is recommended in those situations.
You mean
we have a lot of
the will itself? In the will itself, you have mechanisms to deal with that.
Yes, you have mechanisms to deal with that particular situation. Many times, you will have a husband and wife traveling, and they will want to, reflect their will. They will want their wills to reflect their joint wishes.
Right.
And it takes care of a situation where they are unfortunately dying at under similar circumstances.
Right.
And another situation here in terms of the question, which is a popular situation as well, is what is your experience with liabilities? What is the advice to someone who is the executor of an estate that might have liabilities?
My advice.
Real situation.
Well, the law provides, that the funeral and testamentary expenses and the liabilities of the estate be paid by the executor. So, of the deceased as of the date of death, be paid by the executor.
Right? Nice.
Is that by the executor from proceeds of the estate or no?
Yes. Prior to distributing the assets of the estate, as per the will, debts and liabilities that pertain to the deceased estate should be paid first.
Right. Not the executor out of their own pocket.
Yeah, well, I'm not as being made clear, right? Just out of the assets.
Out of the estate, yeah.
Yeah, the estate. Yeah. And the other question here is, if you are living on a property all your life, grandparents owned, then parents owned, all passed, you now become the owner, but the land was never owned. A tax was paid to the owners of the land each year. Now the children of the owner passed also. The owner of the land has offered you to buy the land, but you are not in a financial position to pay the market price. What is your legal stand on, or do you have a legal stand or claim to the land? And what may be the outcome of this?
So we see a lot of this happening a lot of the time where, people are occupying tenanted land. So they pay rent and they build their homes on tenanted lands. If you are a tenant in those circumstances and you're paying rent for the land, you are entitled to purchase at half the market value. It gets complicated when, people who were the original tenants have not regularized their position and purchased the land previously. So it is a matter for, the landlord to recognize the existing occupiers as tenants, which would be, payment of rent. I don't want to get into too much of this kind of detailed.
Yeah, agreed. Just a quick tangent on that.
You don't know.
Yeah,
you don't know
you
all
need
the
you need the
circumstances.
specifics. You need the specifics.
Yeah.
But in that same vein, just generalizing, if the tenants of the land are not in a position to buy, which is the question, what is the amount that I know that the house is considered chattel on the land. So technically the owners of the house or the structure can remove it if they can and relocate it, right? If of course it's a house that can be done with. However, is there any mechanism whereby if they cannot remove the house and it's a fixed structure, that the landowner has to pay them for the structure if they want to sell over that property to someone else freehold?
Yeah, I mean, in my view, it's not a matter of compelling one or the other in that situation. There's no mechanism to compel either party either way.
But technically, the tenant has no right. Technically,
it could be the subject.
No right. Yeah.
It could be the subject of a discussion, between the parties to come to a resolution. Right.
For example, a sale of the property and a split of the proceeds or something like that for the house and for the land. That's up to their discussion.
We're speculating here.
Exactly, correct. But the question is that the tenant does not have rights other than the occupation of the land. And if they cannot buy, if their tenancy has expired and the owner wants to sell the land, the owner has the right to sell the land and he's not obligated to compensate them for their chattel.
I wouldn't necessarily want to go there,
okay.
Mark.
Okay, well, let's not and leave that to each circumstance, no problem.
That's right.
You're putting me on the spot. You're really putting me on the spot.
It's just, I mean, these are things that we have experienced and people ask these questions. So if it was an easy answer, then great. So people can understand what their rights are. But definitely, I mean, I know that there's the Land Tenants Association that deals with a lot of those things. So I think they are probably a good avenue. But yeah, if we safer not going down that rabbit hole, no problem. Didn't mean to put you on the spot.
Yes, Indu, would you? I know you were on your last slide, and we are about wrapping up time. Would you like to go through the final points? So, do you think you have covered what you had in mind?
Well, thanks for that. I really appreciate the engaging discussion from everyone, all the questions and so on. I think, it's always a good idea to plan, no matter what the circumstances. And to start thinking about those things. These 5 C's that we talked about really reflect the opportunity. If you want to make a will, you really have a lot of choice when it comes to how your assets are divided and who is going to be in charge and administer your estate. It makes things very clear. And I would always, advocate for communication to even reinforce that clarity with family. And these are the things that lead to the comfort of your loved ones and relatives after, your demise. I would also like to suggest that, careful consideration be given to businesses and, the distinction between business assets and personal assets. And these can all be considered, and dealt with by various mechanisms with the help of your advisors, your accountants, your bankers, your lawyers as well. And, it's especially pertinent in our entrepreneurial and our SME environment. So these are things where if we want to sustain business, we have to think about, how we're dealing with the wealth that we generate, the assets that we earn.
Indu, if I could just touch on that, what you just said about the business aspect of it. Based on the entrepreneurs and the small business and micro enterprises, is it a more complicated scenario when someone is a sole trader versus setting up a limited liability company in dealing with their business operations versus their personal assets? Is it that if they are sole trader, all their business is tied up with their personal?
Yeah, if you are a sole trader, it does not necessarily separate your business assets from your personal assets. It's all together. And one of the ways that you can, or one of the means that you can make that distinction is incorporating a company for your business.
Is there a threshold that a micro enterprise may want to reach before saying that they're going to go ahead and do a limited liability company? Would you recommend if they
Depends on the
reach
business.
right?
Depends on the
In other words,
business.
would you say, what value of revenue generating per year, so to speak, would you say that it's safer to do a limited liability and not do sole trading anymore? If it's 10,000, if
Well,
it's 100,000, if it's a million. I know it's a personal choice, but in terms of risk and complicating your estate.
I wouldn't say that there's a particular monetary threshold. What I would say is that, if you form a limited liability company, it insulates the liabilities of the business within that company. So you know what your business is, not only cash flow and what it can generate, but you also know the risks that are involved depending on the type of business. You might be in a very risky business, or you might be in a not so risky business, depending on what you're trading as. So the protection of a company insulates the business from your personal assets.
And also continuity is also easier with limited liability, and succession is easier with limited liability versus a sole trader.
Yes, to an extent. But remember, forming a company by itself does not necessarily mean that you have automatic succession. You might have a company, but you may still need to upskill people to be able to hand that business over.
Correct.
If you operate as a sole trader, even though you have a limited liability company, you still have the issue of succession.
Okay, and if someone dies as a sole trader, can his relatives or his inheritors continue that business if they then set up a limited liability company or operate? Is there any continuity there?
Well, it depends on how his or the individual's estate is shared.
Okay.
All those assets will form part of the estate, and if he's intestate, it goes according to the law. If he has a will, it's dealt with in a different way according to his wishes.
Okay. I'm not going to quiz you anymore.
Mr. President, are you finished? I realize the President has given a good drilling today in you. So I can say, as we seek to wrap up, that it has been a very insightful presentation today. The questions are many, and I know based on what I'm seeing on the chat that a lot of persons appreciate this information that is so troubling to us. Every day you encounter something different, and this bit of information is so useful that I am sure it is going to help all our scores of members here on the webinar this afternoon. So let me, on behalf of the Trinidad and Tobago Coalition of Services Industries and the Tunapuna Chamber of Industry and Commerce, thank you, Indu, for taking the time, using all your skills and competencies as an established attorney, share with us this afternoon. We want you to take back to your board and those at the chamber our appreciation for your collaborating with the TTCSI. And we look forward to future collaboration with you on the way forward and in best interest of our stakeholders and members within the services sector. Let me also thank our president and our CEO and members of staff for working tirelessly to get this session of the ground today. And to all our participants, thank you for being here. We enjoyed every moment, every question, and we will continue to keep in touch with you with other sessions, which will be of benefit to all of us. So thank you once again to all. Have a pleasant evening and a great night.
Thank you, Diane. Thank you, Indu. Indu, I do have one more question for you. You know,
Okay.
are you available to do estate planning for all of us?
But I'm hoping the answer is not no.
Not immediately, not right now.
Oh gosh, thank you very much, Indu. It's a pleasure. Thank you so much for your
My pleasure.
information.
Thank you.
Take care,
Thank you very
everybody. Have a good night.
Bye now.
Thanks, Indu.
You're welcome, Vashti. No problem. Anytime. I hope it addressed some of the concerns. I didn't realize we would have so many questions, but I'm glad I stopped connected.
Oh yeah. I'm happy we
So-
were able to attend to all of the questions.
And you know, it gets a little bit more lively and a little more interactive as well. You know,
Of
so
course.
Yeah.
so I guess are we? Thank you. Are we staying on for a little bit, or
We can sign off. See you.
Yes, we could.
Okay, nice.
Okay.
So I know
right.
all the best.
Thank you. Okay, all the best.
Bye.
Bye. Thanks.
Okay,
Thanks.
right.